it's a pleasure to join you from just outside of Kansas City, where it's a lovely Thursday. Today's Thursday, right? Yes, Thursday morning. And I certainly hope you are having a great morning as well. It's my pleasure to join today to talk about a really important topic in federal contracting, and that is, how does your small business become competitive, more competitive, when it comes to the ability to earn federal government contracts? And certainly we're seeing this become more and more important. You know, there are fewer and fewer contracts awarded by volume by the federal government every year, and there's a shrinking number of small businesses. But those values, those contract values, are getting larger and larger. So when we see this kind of dynamic where we have fewer and fewer businesses competing for fewer and fewer contracts of greater value, how can your business really stand out and earn an award? And luckily, there's some great tools when it comes to mentor, protege, joint ventures, and teaming. So I'm certainly happy to join today to talk about those. This is me. I am the managing member of Schoonover and Moriarty. We are a law firm that works with small business federal government contractors all across the country in all different areas. And even though I am an attorney, and even though we're going to be talking about legal topics here today, I want to caution you, please don't take today's presentation to be legal advice. If you have certain questions, I think it's best to reach out to your Apex or PTAC. It'll always be PTAC to me. But reach out to your Apex. Reach out to a government contracts attorney, whether it's me or somebody else, for more information about this, because certainly your mileage may vary on the topics that we're talking about here, depending on your particular circumstances. And before we break into it, I did want to give a plug for our blog. Everybody loves a good legal blog, right? That's probably the first or second thing you guys check when you're opening your phone in the morning, as you're laying in bed wanting to face the day. You're saying, what's going on in the world of federal government contracts? Well, check out govconbrief.com, because we certainly do update folks on all of the major things that are going on. And as the name implies, our posts tend to be brief. So if you haven't checked out govconbrief.com yet, I would certainly encourage you to do so and make it one of your contracting resources. So as we break into it, just a little bit of a roadmap on what we're going to talk about here today. We're going to start by talking about the Mentor Protege program and why I think it's a great program for businesses to be a part of. We're going to talk about joint ventures, how you form small business joint ventures under SBA's regulations, particularly what they are, why they're helpful, and some of the key considerations to keep in mind. And then we'll contrast that at the very end with a brief discussion on prime sub teams, just as a compare and contrast. So let's break in, and we're going to talk about SBA's Mentor Protege program. But before I kind of talk about SBA's program, I do also want to talk about DOD's Mentor Protege program. DOD does have its own separate DOD-specific Mentor Protege program. It's actually the oldest Mentor Protege program that exists in the federal government, and it used to be, notwithstanding the fact that it was the oldest program, it was perennially like a pilot program, where every year the program would, as it was in the statute as a pilot program, and it would be reauthorized every year by the federal government in the National Defense Authorization Act. Luckily enough, I think 1 or 2 NDAAs ago, the federal government or Congress made it a permanent program. And essentially, DOD's Mentor Protege program is a contract-specific Mentor Protege program. Basically, what it does is it helps the government develop its industrial supply base by partnering experienced DOD contractors with less experienced DOD contractors to hopefully help that less experienced contractor perform under a particular government contract. Now, to qualify as a mentor under DOD's Mentor Protege program, you have to have, I believe they just changed this, but DOD contracts totaling at least $25 million. It used to be $100 million, but now it's $25 million. And you have to apply to DoD to be able to participate as a mentor. And you can Google DoD Mentor Protege Program, and their Office of Small Business Programs has a lot of information on this, but it is an application process. And really the point of the program, as I mentioned, is to help develop that supply base. Now, mentors may get credit for their participation in a mentor protege program for their small business contracting goals, or they may even get reimbursed for some of the costs associated with mentorship. But there is some inducement by the Department of Defense to help these larger businesses participate in DoD's Mentor Protege program. That's different, though, from SBA's Mentor Protege program, the Small Business Administration's Mentor Protege program. And this is really kind of the government-wide, the universal Mentor Protege program, under which one business, the mentor, provides business development assistance to the protege. And the goal of that assistance is to really help the protege become better at competing for federal government contracts, but really not only federal government contracts, really to help it grow and develop its business capabilities overall. The key part of this agreement is certainly the mentor protege, or excuse me, the key part of this program is the parties' mentor protege agreement, which they're going to develop and submit to the SBA for approval. And that agreement is going to identify the items of assistance that the mentor is going to provide to the protege. Once SBA approves this agreement, it's going to last for a period of 6 years. The agreement, the parties have to confirm to SBA that every year that the mentor is providing the areas of agreed upon assistance, and do some other kind of annual reporting. But really, unless there's reason for SBA to rescind the agreement, or unless one of the parties renews it, it's going to renew automatically every year for that 6-year duration. Under SBA's Mentor Protege program, there are some limitations to keep in mind. And that is, they're more specifically geared at the protege, where essentially the protege is limited to having only 2 mentor-protege relationships over its lifetime. That is, the protege can only participate as a protege twice under SBA's mentor-protege program. And so really that imposes a pretty significant limitation at the outset, where proteges need to make sure that they're partnering with a mentor who really can help it develop its capabilities and its experiences to become more competitive for these federal government contracts. Usually, SBA believes that there should only be one mentor-protege agreement in place at a time, but SBA might approve a second, or the protege's second, mentor-protege relationship to run concurrently with the first, if the protege can show that there's no conflict between the two. That is, if they're not going to be forming joint ventures that compete under the same contracts or under the same NAICS code. They're going to be operating in different geographic areas, or the mentor under one agreement is going to be providing a different type of assistance than the mentor under the other agreement will provide. So there are some key limitations to keep in mind, certainly for proteges. For mentors, there are fewer limitations, because essentially SBA wants to encourage folks to participate in the mentor protege program. Now, there is no lifetime max for a mentor on the number of mentor protege relationships it can have over its lifetime. There is still that presumption that it's going to have one agreement at a time, but SBA may approve up to 3 concurrent relationships for a mentor, again, if it shows that there's no conflict between the two. And here, I want to say there's no restriction from SBA that just because you're a protege in one agreement doesn't mean you can't participate as a mentor in another agreement. So that's kind of an interesting dynamic in SBA's program, where for DoD's mentor protege program, you're really limited on being a protege, just a single protege at a time. To be eligible, who's eligible when it comes to SBA's mentor protege program? Well, really the eligibility requirements are focusing on the protege. And in order to be eligible as a protege, the primary consideration is that you have to be a small business under your primary NAICS code, or if you're applying under a secondary NAICS code, that you have to be a small business under that NAICS code, and you actually have to do business under that NAICS code. You can't just apply for a mentor protege program under a NAICS code that you don't actually do any work under, thinking like, well, I'm a large business under my primary NAICS code, but if I apply under this other NAICS code, I'm a small business, so I'm just going to apply under that. The only way you can do that is if you actually do work under that secondary NAICS code. Now, to determine whether you are a small business, I know we've had webinars certainly with the Maryland Apex before, discussing small business size rules, and I would certainly encourage you to take a look at those. But SBA is going to determine size essentially under those rules, and it's going to take a look at if you have any affiliates. What does that affiliation do to your size, and how does that impact your size? So certainly as you're thinking about this mentor protege agreement, I think it's a good time for a potential protege to have a size audit. And I do use the term audit because it's painful. But I think it is important to have that analysis done to determine whether you really are a small business. This is certainly a good excuse to do that. Now, that's the primary eligibility. You just have to be a small business. You do not have to have any particular socioeconomic designation, although you can be an 8A company, you can be a woman-owned small business, you can be an SDV OSB, you can be a hub zone company, you can be any of the above, or all of the above. The key consideration is just that you are a small business. And so this really is a universal mentor protege program where it's not just targeted to any specific socioeconomic agreement. For mentors, you can be eligible regardless of your business size. That is, you can be a large business, you can be a small business, you can be anything in between. The key consideration is just that you demonstrate that you have the ability to provide the assistance that you've pledged to provide under the mentor protege agreement. SBA wants to make sure that you can actually do what it is you say you're going to do under that agreement. And of course, if you've ever been up for suspension or debarment, if there's indictments or back taxes or anything like that, SBA is going to take that into consideration as well, because it wants to make sure that you really are the type of business that it wants mentoring others. But those are the primary eligibility criteria to be a mentor. It's focusing on, can you actually provide mentorship as you say that you're going to provide? The benefits. So we've talked a lot about, we're on slide 10 now, and we're getting to the, gee, what's in it for me? But really here, the benefits to participating in SBA's mentor protege program really at some level should be somewhat obvious. At least some of the benefits should be somewhat obvious. That is, as the protege, you're working with a company who has said, I'm going to provide certain business development assistance to you as my protege. And so by participating in the program, this 6-year program, you should leave stronger. You should leave more able to compete for business opportunities. You should leave with better past performance, with better technical capabilities, with better management, with better all of the above than before you entered into the program. And so that really is the key benefit for small business participation, but it goes beyond that as well. So there's exemptions for affiliation for the items of assistance that the mentor provides to the protege that are under the agreement. So that's a key consideration to keep in mind. Really, if you're doing the agreement correctly, and if you have that close relationship that is contemplated under the mentor-protege agreement, there is a risk of affiliation. Where your business may be considered, too close or too dependent on your mentor. But that would be a really kind of goofy result if SBA encouraged mentor protege program participation on one hand, but then said, oh, but we're going to find you affiliated if you do it right on the other. So what SBA has done is they've said, for the items of approved assistance, for the items of assistance that are in your mentor protege agreement, we're not going to find you affiliated with your mentor for those reasons. We're not going to find you affiliated for complying with your mentor protege agreement. It is not, keep this in mind, it is not a blanket exemption of affiliation between a mentor and a protege. You can still be affiliated with your mentor for other reasons. But if it's in the agreement, there is an exemption for affiliation. So when I work with proteges and mentors, I'm saying if there's any assistance that we think that might be provided under this agreement, let's put it in the mentor-protege agreement, particularly if that assistance may give rise to a finding of affiliation between the parties. We want to make sure that we're getting an exemption from that affiliation in there. And that can be very, very powerful as it can help keep small businesses small. I've seen that happen. So it's certainly a consideration to keep in mind. The mentor can also make a 40% equity or take a 40% equity position in the protege for purposes of helping the protege raise capital. But that's really crucial, not only for a protege where maybe you're getting a capital infusion, but also for a mentor where you're saying, if the mentor is looking at this and saying, what are the benefits for me? And all of a sudden you're able to tell them, well, I can give you an equity position of up to 40%. And so that way, all of the benefit that I get from this agreement, you'll be getting a part of that as well. That can be a powerful inducement for mentors, especially also when we talk about mentor-protege joint ventures. And we're going to talk about them here in just a moment. But the general rule for a small business joint venture is that both venturers have to be small businesses. That rule is relaxed, though, in the case of a mentor-protege joint venture. In that case, under a mentor-protege joint venture, the joint venture will qualify as a small business so long as the protege is a small business, meaning that the mentor can be a large business and the joint venture can still be small if the protege is small. And that's a tremendous advantage because now we have large businesses able to participate as a joint venture member, in small business set-aside procurements. And so when you're looking at these competitive advantages, if you're wanting to explain to a possible mentor, here's what's in it for you, really there is the ability to participate in small business set-aside contract opportunities that they might otherwise been ineligible for. So that's a tremendous advantage when it comes to SBA's mentor-protege program as well. And I will say that ability to participate in mentor-protege joint ventures is unique to SBA mentor-protege agreements. So there could be some DoD contracting benefits if you're participating in a DoD mentor-protege agreement. But if you want to participate in a small business joint venture, it needs to be an SBA mentor-protege agreement. So when we talk about the mentor-protege agreement, this is really the heart and soul of SBA's relationship. And you can find a template agreement on SBA's website But really, the point of the agreement is for the parties to identify the assistance that the mentor is going to provide the protege. And we see some items of assistance or some area of assistance that SBA has put in the template agreement. I will say these are just guides. And you can have any of these. You can have one of these. But really, it's up to the parties to explain what the assistance the mentor is going to provide the protege, how that is going to help the protege develop its capabilities and better compete for government contracts, when that assistance will be provided, that is when it'll start, when it'll end, and how the parties are going to determine whether that assistance is being provided. That is some type of objective measurement where the parties can measure that assistance is being provided. And so certainly when you look at the mentor-protege agreement, that's what I encourage folks to keep in mind is how the assistance will be provided and how it'll be measured by SBA, and how it will help the protege are really key aspects of that agreement. I mentioned mentor-protege joint ventures. Sorry, my dog is banging at the door to get in. I mentioned mentor-protege joint ventures. We're going to talk about joint ventures here just in more of a moment, but I will say it's important to keep in mind that having a mentor-protege relationship does not automatically establish a joint venture. These are two separate, albeit sometimes related, topics, where just because you have one doesn't mean you have the other. And just because you have one doesn't necessarily mean you need the other, although it might in some cases. Now, if you have a joint venture, you still have to follow SBA's regulations, and SBA must approve the mentor-protege agreement before the joint venture can bid. And so keep that in mind when it comes from a timing, from a sequencing standpoint. In order to have the benefit of the mentor-protege joint venture exception, SBA does have to approve that agreement before any bid is submitted. So as far as proteges go, I think mentor-protege agreements are really a wonderful opportunity to gain experience and to learn from a trusted partner, somebody that is successful in the government contracting realm. I think it's just a great opportunity. And for my clients and prospective clients that haven't yet participated in a mentor-protege agreement, I think I tell them that it really is, particularly again as we see some of these considerations take place, the parties really do need to think about these to become more and more competitive. But I think it's really important to ensure that the party that you're working with, the mentor that you're working with, really is somebody that you can see yourself working with long term. It's a 6-year relationship. And so when we consider, if we analogize a mentor-protege relationship to a marriage, you certainly want to start dating somebody first. Maybe consider subcontracting with a possible mentor or protege before you enter into one of these agreements to really make sure that you're compatible with them. Mentors, I think it's also a great opportunity to assess really where they are in their contracting experience. What do they do well? What do they not do so well? What might they learn from their protege? And how might they invest in those kind of younger and newer established companies to really become more competitive themselves as well? Where folks get into issues with the mentor-protege program, and sometimes there are issues, is where I see them just kind of treating it as a vehicle for joint venturing. That is, if they identify a contract opportunity and they say, I want to joint venture with this company, this large business, and so I need to enter this mentor-protege agreement. That's true, but if it's just solely for that vehicle, then that's sometimes where things come and can get dicey, because maybe if you don't win that contract, then all of a sudden you have a mentor who's not committed to the relationship. Or worse yet, if you've won the contract and don't have experience working with your mentor, and you know, you're oil and water. Now all of a sudden you've got a 6-year relationship and a 5-year contract, and you've got to learn how to get along and to make that performance successful. And so certainly there can be issues that come into play there as well. So I encourage folks to try and get to know your mentor or your protege before entering into this type of agreement. And so with that, we're going to transition now, not so gracefully, but we're going to transition now into talking about joint venture relationships, where a mentor-protege agreement is a business development relationship. It's fostered, or it's focused on developing the capabilities of a protege to really grow and develop. A joint venture relationship is more focused. That is, this is where the parties are saying, we're going to work together to pursue a specific federal government contract opportunity. And SBA's regulations have particular rules if parties want to do that. A joint venture under SBA's regulations is a separate legal entity formed for the limited purpose of pursuing, as I mentioned, a specific federal government contract opportunity, and it is a separate legal entity. We have two or more venturers forming a new business, and that new business is going to pursue the federal government contract opportunity or subcontract opportunity in the separate legal entity's name. The venturers are going to be the owners of that business, of that separate legal entity. But most of the time, especially considering how SBA's rules used to look, most of the time, the joint venture entity is actually what's called an unpopulated entity. There's some exceptions to that now, but most of the time it's going to be an unpopulated entity, meaning that the joint venture entity itself is not going to actually employ the individuals who are performing under that government contract. Rather, the venturers are going to perform in their as essentially co-prime contractors through the legal fiction that is the joint venture entity. Let's take a look at it, because it can be somewhat confusing. But if we start at the bottom, we have two companies, ABC and 123, form ABC 123 LLC. ABC 123, this middle entity, is the joint venture entity. And by the way, this is the extent of my graphic design capabilities. So if you're very impressed with this chart, thank you very much. I think you should be. But we have ABC 123, which acts as the joint venture entity, which then contracts with the government or with another prime contractor as its subcontractor. But the contract would be issued in the name of ABC 123. But because ABC 123 doesn't actually employ any individuals who are going to perform under the contract, ABC and 123 both separately perform their respective scopes as, you know, as I mentioned, de facto prime contractors. Now, the joint venture entity can subcontract out to third parties as well. But really, ABC and 123 are essentially those kind of de facto co-prime contractors that are going to be doing that work. So in some respects, ABC 123 is a legal fiction. It's kind of like a pass-through entity in some respects, at least in the case of an unpopulated joint venture. So why would you do this? Why would you consider joint venturing? Well, collaboration, because now ABC and 123 get to combine their resources, their capabilities, their past performance, all of that to better position themselves to pursue a federal government contract opportunity that might have otherwise been out of their reach. You know, if ABC and 123 can each independently perform the contract, they're probably not going to form a joint venture to pursue it, unless maybe there's a reason to kind of limit their liability or something like that. But if they can each perform as a prime contractor, I'd say it's not common that they would form a joint venture to do it. Rather, in that case, they would probably pursue it each as prime contractors individually. But where ABC and 123 maybe lack the capabilities to do it, then by forming the joint venture, they're essentially combining their capabilities. You know, kind of the Captain Planet approach, where each one has the ring, and they, you know, and they do the earth, fire, wind, water. And then Captain Planet comes and it's got all the powers. That's kind of like the joint venture. I don't know why I just thought of Captain Planet on a random morning in 2023, but here we go. Good, this is being recorded. They combine their capabilities and their resources and everything to perform that opportunity and hopefully earn contracts of a larger and larger value. And again, in most cases, ABC and 1, 2, 3 are each going to have to be small businesses, each going to have to qualify as a small business under the solicitations NAICS code in order for the joint venture itself to qualify as a small business. But in the case of a mentor-protege agreement, for example, if 1, 2, 3 is ABC's, I should come up with actual names for these companies. But if 1, 2, 3 is ABC's SBA approved mentor, then 1, 2, 3 can be a large business. It can be Lockheed Martin, it can be Raytheon, it can be SAIC, whatever insert large business federal contractor, Honeywell you want to put in there. You know, it can be a large business, and that joint venture, so long as it meets SBA's rules, can still qualify as a small business joint venture. And so that is a very powerful inducement for these companies. Why are they helpful? Because they really do help companies preserve their small business status, where if they're doing a joint venture in compliance with SBA's regulations, they get an exemption from affiliation for that joint venture. It's a limited exemption. It doesn't last forever, but they certainly get an exemption for affiliation from that joint venture. And as I mentioned, it is an alternative to subcontracting in that it helps businesses kind of co-prime under these contracts, where otherwise they might have this work might have been out of their reach. So they get to joint ventures here really get to consolidate or combine their resources and their experiences. SBA's regulations say that when an agency considers or evaluates the technical capabilities, the experience, the past performance of these joint ventures, they have to not only consider the joint venture entities' capabilities and experience and performance and all of that, but has to consider the constituent members' capabilities as well. And so really it does help these companies earn more contracts through kind of these consolidated or these combined capabilities. Now, though, a really good benefit for small businesses is now small businesses can actually rely on the performance that they gain as small business participants in a joint venture as part of their past performance as well. That is, if ABC Corp from our example earlier is in this joint venture, ABC 1, 2, 3, but then ABC separately pursues a different contract later on, it can now claim its past performance under ABC 1, 2, 3 to the extent it has done work for ABC 1, 2, 3. So that's a great benefit for these small businesses as well. And by combining, you know, equipment, personnel, facilities, all of these type of things, the goal is that these ventures, these small businesses, will be able to perform and pursue contracts that were otherwise out of their reach. There's also a key benefit when it comes to facility clearances, where SBA's regulations now say that that the joint venture entity does not have to have a facility clearance itself, because oftentimes these joint venture entities are formed for the purpose of of pursuing a specific opportunity. And so maybe the joint venture entity itself does not have the requisite clearance. And before, that used to be up to the agency's discretion. And oftentimes DoD required even a joint venture entity to have that clearance. But now SBA's regulations say that a small business joint venture can rely on the clearance of the constituent members. The joint venture entity doesn't have to have it itself. Now, if cleared work is the primary and vital work under the contract, then the managing venture, that small business venture, has to have the clearance in order to do that work. But if it's ancillary work, then the non-managing venture, in some cases the mentor, can have that clearance. So that can be a benefit to joint ventures as well. These do take some time to put together. And they take some time because the joint venture entity has to be registered in SAM, which means it has to have its tax ID number, its employee ID number. I've got DUNS in here, but it's got to have its unique identifier. It's got to be registered in the state. All of these type of things. It's got to be set up in SAM before the joint venture actually bids on any contract opportunities. And so I'll get calls on occasion from folks that say, I've got a joint venture that's bidding on a contract tomorrow. Can we get it set up? Probably not, because it's got to be set up in SAM. It's got to have all of this stuff taken place before it actually submits its bid. So make sure, if you're considering a joint venture entity, or if you're considering bidding with a company as a joint venture, go ahead and get that set up now. You can get it set up in SAM without even having the solicitation issued. You can have a joint venture entity just sitting there, and that's fine. At least until it wins its first award. So I encourage folks to start that process early. And in some cases, particularly in the case of an 8A sole source contract opportunity, even the joint venture agreement has to be approved by SBA before the contract is awarded. Now, in most cases, though, you just have to have a joint venture agreement in place, a compliant joint venture agreement in place before you submit your bid, because that's when size is going to be determined. So keep that in mind, that also before you submit a bid, you have to have a compliant joint venture agreement. And a non-compliant joint venture agreement will mean that the joint venture does not qualify as a small business. So make sure that you are taking the time to put together a compliant joint venture agreement. Make sure that the agreement is reviewed by somebody who is aware of the current regulations and how those regulations are interpreted by SBA, because certainly if the agreement doesn't comply, the joint venture agreement will not get, or the joint venture, will not get the affiliation exception. There's also performance requirements for joint ventures that have to be met. The first is, of course, the limitation on subcontracting that's going to apply to just about every small business set-aside procurement, where that is saying that the prime contractor has to perform, together with any similarly situated entities, has to perform a certain percentage of the contract's value, of the work by contract value. And there's going to be different limits depending on the industry under which the work is performed. So for services contracts, it's going to be a 50% limitation. For general construction, it's an 85% limitation, meaning that the prime contractor would have to perform at least 15% of the work. But for joint ventures, there's a second performance requirement that comes into play that says, of the work that the joint venture performs, meaning of the work that is not subcontracted out, the managing venture, or the small business, the protege venture, or whatever the case may be, has to perform at least 40% of the work that is performed by the joint venture. And that work has to be substantive, so that the managing venture gains experience performing the work. Let's take a look at it. So here we have a general services contract that has been awarded to a small business joint venture. It's a small business set-aside services contract, IT services, for example. or legal services. And that small business prime contractor, that joint venture, subcontracts out to third parties 50% of the work in compliance with the limitation on subcontracting. It can subcontract out up to 50% to non-similarly situated entities. It could perform the whole thing, but let's assume that it's subcontracted out half of the project. So then we see the joint ventures work share on the left side of the circle. The partner venture, the non-managing venture, can perform 60% of the joint venture's work. The managing venture has to perform at least 40% of the joint venture's work, or under this example, 20% of the total contract. Now, again, if the joint venture didn't subcontract out any work, then all that means is that the managing venture's size or performance share increases as well. So if the joint venture performs 100% of the work, then the managing venture has to perform 40% of the overall work. So keep that in mind. There are performance requirements for joint ventures. We also have to have a compliant joint venture agreement. Excuse me. The joint venture has to have a written agreement that complies with SBA's regulations. And as I mentioned, this agreement has to be in place at the time the joint venture submits its bid under the contract opportunity. This includes having contract-specific provisions relating to that opportunity. So a lot of times what we do is we create what's called like a master joint venture agreement that identify a lot of the terms that govern the joint venture. But then we have a contract-specific addendum where the parties identify the contract opportunity that is going to be pursued by the joint venture, performance requirements under that, who's going to be the responsible manager, equipment, facilities, and resources that are going to be provided under the joint venture relating to that contract, and division of labor, all of that type of stuff. We'll have a separate addendum that identifies these contract-specific items. So keep that in mind, that you can create a joint venture agreement in advance even of a solicitation being released, but you just need to create an addendum to that agreement to cover specific government contracts. I'm not going to walk through these, but there are some universal joint venture agreement requirements. And really the point of these next two slides, this slide and the next slide, is just to show you that there are detailed requirements when it comes to having a compliant joint venture agreement. Now, I will say for each one of these requirements that we're going to talk, or excuse me, that are on the screen, SBA's Office of Hearings and Appeals has a kind of like a body of case law that says, okay, what's required here, what's not required, how detailed do these have to be? So this goes to show that when you're working on one of these joint venture agreements, there are detailed requirements to keep in mind. And please, please, please do not use old joint venture agreements. Do not use template joint venture agreements that you might find online, even if they're published by the SBA, because these regulations do change. And they change fairly frequently. And if your agreement doesn't comply with the joint venture regulations that are in effect at the time you bid, it may not be compliant. So, you know, have help from somebody who knows about these requirements. Have help from somebody in preparing this joint venture agreement. And again, it has to be in place at the time you submit your bid. So that's the joint venture relationship. And I want to contrast that here just for a few minutes by talking about prime sub teams. And I don't want these to get lost in the shuffle, because I still think that prime sub teams are probably the most common way to work with somebody else under a federal government contract. And they're different from a joint venture relationship. Where a joint venture relationship, we're forming a new legal entity that's owned by the venturers, and those venturers are performing as you know, kind of co-prime contractors, and are each obligated to ensure the performance of the contract. Under a prime sub team, it's much simpler. It's much more flexible, where really you have only the prime contractor that has privity of contract, that has a contractual relationship with the federal government. And that prime contractor is solely responsible for ensuring that all of the deliverables and all of the scope of the contract are met. It has that obligation to the government. But the prime contractor can subcontract out some of that work to one or more companies. And those companies, through that subcontract relationship, are going to become obligated to the prime contractor to perform that work. So here's the relationship. Before, you know, it was a little more complicated. Here it's much more linear, where we've got you know, the government contracting directly to the prime contractor, ABC, who then subcontracts a portion of the work to one or more subcontractor entities. And this is really the kind of the quintessential relationship where, you know, 123 Corp is going to have privity of contract with ABC, who's then going to have privity of contract with the government. Importantly, there is no contractual relationship between the government and the subcontractors, meaning that the prime contractor is responsible to the government for all of the work under the contract, but those subcontractors are going to be responsible to the prime contractor in accordance with their subcontracts. Now, there are some key considerations to keep in mind from a federal contracting standpoint, but I will say that prime sub teams are ultimately governed by state law. That is, the rights and obligations between a prime and a subcontractor are generally set forth or going to be determined under state law. And so you need to make sure that when you have one of these agreements, you're having local counsel take a look at them to ensure that your rights and obligations are protected under state law under them. But there are some key considerations to keep in mind. First, I think really the prime sub relationship is essentially, in my experience or in my mind, it's really the product of two separate agreements. And the first is the teaming agreement. First is the agreement between the prospective prime contractor and the prospective subcontractor, where the prime contractor says, I'm going to pursue this prime contract opportunity, but I want you on my team to perform certain work under that prime contract. And this is going to lock us into place as prime and sub, so that I can, as the prime contractor, make sure that I've got a team under me to perform this work if it's awarded. The teaming agreement is going to focus on defining the parties' roles and responsibilities when it comes to proposal preparation and submission. But it's also, I think it should also obligate the prime contractor to also require or allow the subcontractor to perform a certain part of the work if the prime contract is ultimately awarded. So this basically locks the parties into the relationship. It's going to have key terms about their relationship, or if there's key provisions that need to be in any subsequent subcontract, to make sure that those are in there as well. You're going to identify the parties and their responsibilities. You're going to identify the solicitation, who's doing what when it comes to proposal preparation. Generally, if I'm the subcontractor, I want to say in the proposal preparation for the work that I'm going to do, because you know, I want to make sure that when that's presented to the government, that how I'm going to perform that work is ultimately included in that proposal. So that way, you know, I'm performing how I want to perform. I'm also going to, you know, identify what my pricing is for that, so that they can include that in the contract. I want, as a prospective subcontractor, I want my areas of performance locked in, minimum, to say, once that prime contract is awarded, that prime contractor is going to give me a subcontract to perform you know, at least this percentage of the work, or at least these task areas. And I also want any key FAR flow down provisions or limitation on subcontracting provisions, all of that included in the teaming agreement. And then once the prime contract is awarded, that's where the subcontract comes into play. That's a much more detailed document where the parties are going to specifically discuss, here's your scope of work, here's the deliverables and the performance requirements that you're going to have to meet, subcontractor, and here's how I'm, as the prime contractor, going to pay you under this agreement. That's the more detailed, more structured document that relates actually to performance. Now, a lot of this can be negotiated even before the prime contract is awarded, but eventually the subcontract is going to replace the parties' teaming agreement. You're going to have some key federal requirements in this agreement, FAR flow downs or OCI provisions in there. If I'm the prime contractor, I want a limitation on subcontracting provision that says I can reallocate work among us or among all of my subcontractors in order to avoid a limitation on subcontracting violation. If I'm the subcontractor, I want to limit that to maybe the least profitable work or only the minimum extent necessary to avoid a violation. Subcontracts often have non-disclosure, non-compete, non-solicitation provisions that kind of keep the parties in their lane and make sure that they're not soliciting each other's employees or competing against each other for this work. Wage compliance requirements. If I'm the prime contractor, I want to make sure that my subcontractors are fully responsible and will indemnify me for any SCA compliance or Davis-Bacon compliance, executive order compliance, collective bargaining act compliance, all of that type of stuff. If I'm the subcontractor, I want to make sure that that I'm entitled to a price adjustment under my subcontract if those wage determinations or what have you increase. Changes to the subcontract, to the scope of work, who's going to authorize those and how are they going to be authorized? Dispute resolution procedures, both between the prime contractor and the subcontractor. And then if there's a dispute between the subcontractor and the government, remember where I said that the subcontractor doesn't have privity of contract with the government. So the subcontractor can't submit a claim to the government if the government does something to mess up the subcontractor's performance. So if I'm the subcontractor, I want a dispute resolution pass through where they have to pass through or sponsor one of my claims if I have any against the government. Termination provisions. If I'm the prime contractor, I want the right to terminate the subcontract for convenience, especially to the extent my prime contract is terminated for convenience. As well as, both parties need to be aware and understand what their default obligations are or their obligations in the material, if there's a breach of the contract and how those are cured. So there are certainly key provisions to keep in mind. But again, a lot of this is going to be determined by state law, even though there will be key federal considerations as well. So, with that, I wanted to leave a couple of minutes for questions. We're at the end here. So just as a recap, really consider a mentor-protege agreement. If you've got a company in mind that you think might be a good one to learn from, I think small businesses really can get really good mentoring from established and experienced businesses and really get some affiliation protection and joint venture opportunities as well. If you're pursuing joint venture, please make sure that you're complying with SBA's regulations and that you have that compliant joint venture agreement in place before the bids are submitted. Prime subcontractor teams are very flexible, but there are some key small business requirements to keep in mind, and you are going to need to keep in mind some state requirements as well. So with that, that's what I have today. If anybody has any questions, I see the little notification on the chat bar. It looks like there might be a few, but my contact information is on the screen. Please feel free to reach out to me by email. Please reach out to me by phone. Send me a letter. Whatever the case may be, connect with us on GovCon Brief. I'm certainly happy to connect with everybody and happy to answer any questions.
Thank you, Matthew. That was great and really detailed as usual. I'm glad we're recording this because there's a lot of information that a lot of people might want to go back and watch, listen again. Okay, so let's look through a couple of questions in the next 5 minutes. First one is, what's the best way to find a mentor?
That's the number one question that I always receive. And I'm going to say it really depends on your industry. There's no repository of which I'm aware where a company can go in and say, hey, I want to be a mentor and here's what I can provide. And protege can say, I want to be a protege and here's what I need. And let's meet up. That's $1 million idea if anybody wants to take it. But I tell folks, consider your industry. You know who's doing well in your industry. You know those companies that you look up to, that you emulate. You know those businesses that you've worked with in the past. You know those people that you've worked with in the past. Maybe you used to work for a company and still have contacts there. Maybe somebody that used to work for you went to go work for somebody else and you still have a good relationship with that person. But think about your industry. Think about who's successful and how they're successful and how you might approach those people. But that's really, I think, the best way. I mean, I even tell folks, think about your competitors, because maybe you have a competitor who is maybe getting ready to size out, or maybe they're losing, for example, their 8A eligibility here in a little bit. And they're looking for ways to nonetheless stay relevant in the 8A program. Look at these opportunities with even some of your competitors to think about who might be a good mentor for you in that case. This really is the number one question that I get when it comes to the mentor protege program. And I say, there's no right answer, there's no wrong answer. So long as you're looking for a mentor that can provide the assistance that you need.
Right. Next question is, can I be enrolled in both the SBA and DoD mentor protege programs?
Yes, so long as they don't conflict. When you apply to SBA's mentor protege program, they're going to ask for you to disclose any other agency mentor protege programs that you participate in. It's not a deal breaker, but if they conflict with each other, that's where SBA or DoD is maybe going to have some issues with it. So that's going to be the primary consideration.
Okay, and the next question is, what about startups? Are startups eligible for any of these mentorships?
Yes, they are. They are eligible. Again, you just have to be a small business under your primary NAICS code. I will say for startups, sometimes it does get difficult because a lot of times a mentor wants to work as a joint venture or through a joint venture, and your ability to perform some of the contracts that might be being considered by the mentor could be somewhat limited. And again, there are self-performance requirements in there. So you want to make sure that if you are in a mentor-protege agreement, again, one of the things that as a protege you can bring is the opportunity for this mentor to compete for these contracts. And so you want to make sure that you are in a position as a protege to actually be able to perform the contracts that you might be expected to perform. So I would that's the only thing or the biggest thing in my experience, that when startups get involved in a mentor protege relationship, that sometimes there can be a friction point, but otherwise, yes, you are eligible to participate as a protege.
Okay, wonderful. That's all we have time for today. So thank you so much, Matthew, for great information as usual. And thank you all in the audience for asking great questions. I've posted some useful links in the chat box. So please do have a look through those. And we have a matchmaking event coming up next month in La Plata, Maryland. So have a look at that, see if that is attractive for you as an opportunity to meet primes and agencies. And of course, don't forget to contact your Apex Accelerator counselor for assistance. So thanks, everybody, and we'll see you at a future Apex webinar. Bye-bye.
Take care. Thank you.